I never thought a Tuesday morning would turn into the worst day of my life. But when I heard the chainsaws roaring outside my window at 7 a.m., I knew something terrible was happening. My name is Xavier Xanders, and I live in the Ridgemont Heights subdivision in Scottsdale, Arizona. It's one of those places where every house looks vaguely similar. The lawns are kept pristine, and the HOA rules could fill a small library. But I loved my house because of what came with it. 3 magnificent oak trees that had been growing in my front yard for over 60 years. They were there long before the subdivision existed, back when this area was just desert scrubland with pockets of hardy trees that had somehow survived. I threw on my clothes and ran outside, my heart pounding. What I saw made my blood run cold. 2 men in bright orange vests were working on the largest of my oak trees, their chainsaw biting into the thick trunk. Wood chips flew everywhere, and I could see they had already taken down one of the smaller oaks. It lay sprawled across my yard like a fallen giant. "Stop! What the hell are you doing?" I shouted, running toward them. The nearest worker turned off his chainsaw and pulled out some earplugs. "HOA authorization, sir. We're just doing our job." "I never authorized anything. Those are my trees." The second worker climbed down from his position and walked over with a clipboard. "Says here the Ridgemont Heights HOA board ordered the removal. Something about view obstruction complaints from neighboring properties." I felt like I'd been punched in the gut. "Let me see that." He handed me the paperwork, and sure enough, there was an official-looking work order from the HOA, signed by the board president, a woman named Patricia Pennington. I'd met her exactly once at a community meeting, and she'd struck me as the type who enjoyed having power over people. She was in her late 40s, had that "can I speak to the manager" haircut, and wore her position like a crown. "You can't do this," I said, my voice shaking with anger. "These trees are on my property." "According to the HOA covenant, they have the authority to maintain community aesthetics," the first worker said, sounding bored. "We got the order, we do the work. You want to fight it, talk to them." "I'm talking to you. Stop cutting down my trees, sir. We're already contracted and paid." "If we stop now, we're in breach of contract. Take it up with the HOA." I stood there helplessly as they fired up the chainsaws again. I called the police, but when the officer arrived 20 minutes later, he looked at the paperwork and shook his head. "This is a civil matter, sir. If the HOA has the authority under your covenant agreements, there's nothing I can do. You'll need to handle this through the courts or your HOA board." By noon, all 3 of my beautiful oak trees were gone. What remained were 3 ugly stumps and a yard full of sawdust and debris. My neighbors across the street, the Hendersons, stood on their porch watching with satisfied expressions. Their house sat slightly uphill from mine, and my trees had partially blocked their view of the Camelback mountain range in the distance. I was shaking with rage as I marched to the HOA office, located in the community center at the entrance of our subdivision. It was a nice building, probably worth close to $2 million, with meeting rooms, a gym, a pool, and various recreational facilities. My HOA fees of $300 a month helped pay for it, along with the fees from the other 230 homes in Ridgemont Heights. The receptionist, a young woman who looked uncomfortable, told me Patricia wasn't available. "She's in a meeting right now." "Then I'll wait," I said, sitting down in the lobby. "She might be a while." "I've got all day." 3 hours later, Patricia finally emerged from her office. She was exactly as I remembered. Medium height, blonde highlighted hair in that aggressive bob cut, designer workout clothes that probably cost more than my monthly mortgage, and an expression that suggested she smelled something unpleasant. "Mr. Xanders," she said, her voice dripping with false sweetness. I heard you wanted to speak with me. You cut down my trees. The HOA exercised its authority to maintain property values and community standards. Your trees were blocking the mountain views from several properties and negatively impacting their values. Those trees were there before this neighborhood even existed. They were part of my property. She gave me a condescending smile. When you purchased your home, you signed the covenant agreement. Section 12, subsection 4 clearly states that the HOA board has the authority to remove any vegetation that negatively impacts community aesthetics or property values. Multiple neighbors complained about your trees. Let me guess, the Hendersons. I can't disclose who filed complaints. That information is confidential. I want to see the board meeting minutes where this was discussed and voted on. Her smile tightened. The board has the authority to make executive decisions in cases affecting property values. So there was no vote, no discussion, no notification to me. We sent you a notice 30 days ago. I never received any notice, she shrugged. We have proof of mailing. Not our problem if you didn't check your mail. I knew she was lying. I checked my mail religiously. I want to see this proof. You can submit a formal request in writing. We'll respond within 30 business days as required by the bylaws. 30 days. You cut down my trees in one morning, but I have to wait 30 days for information. That's the process, Mr. Xanders. Now, if you'll excuse me, I have other matters to attend to. She turned to walk away, but I called after her. This isn't over. She looked back with that infuriating smile. Have a nice day. I went home and immediately started researching. I pulled out all my HOA documents, the covenants, the bylaws, everything I'd signed when I bought the house 3 years ago. I read through every single page, making notes. Then I started looking into Arizona property law, HOA regulations, and tree removal statutes. What I found made me even angrier. Yes, the HOA had broad powers under the covenant, but there were limitations. They were required to provide written notice of any action affecting a specific property owner. They were required to hold meetings and take votes on major decisions. They were required to give owners the opportunity to appeal. They had done none of these things. I also discovered that my oak trees were actually protected under a Scottsdale city ordinance for native and heritage trees. Any tree over a certain age and size required a permit for removal, even on private property. I called the city the next day and confirmed that no permit had been issued for my address. That's when I knew I had a case. I spent the next week consulting with 3 different attorneys who specialized in HOA disputes. The first 2 were pessimistic, saying that even though the HOA had violated proper procedure, the cost of litigation would likely exceed any damages I could recover. The third attorney, however, was different. His name was Marcus Fitzgerald, and he'd been fighting HOAs for 20 years. He was a tall, lean man in his 50s with sharp eyes and a reputation for taking on cases other lawyers wouldn't touch. They screwed up, he said after reviewing my documentation. Multiple ways. First, no proper notice. Second, no board vote on record. Third, and this is the big one, they violated city ordinance by removing protected trees without a permit. That's not just a civil violation. That's potentially criminal. So I can sue them. Oh, you can definitely sue them. The question is what you want to achieve. We could go for damages, replacement costs for mature trees, diminished property value. But here's the thing about HOAs. They're usually judgment-proof in the sense that they'll just levy a special assessment on all the homeowners to pay any judgment. So everyone in the neighborhood ends up paying for the board's mistakes. What's the alternative? He leaned back in his chair, a slight smile on his face. We go nuclear. We sue for gross negligence, willful misconduct, and violation of city statutes. We demonstrate a pattern of abuse of authority. And then we ask the court to remove the current board and place the HOA's assets into receivership. In extreme cases, courts have even ordered the dissolution of HOAs or the forced sale of HOA assets to satisfy judgments. The community center, I said slowly, worth about $2 million according to the property records, your mature oak trees. Replacement cost for trees of that age and size could run anywhere from $50,000 to $200,000, plus diminished property value, plus emotional distress, plus punitive damages if we can prove willful misconduct. Let's do it. Marcus grinned. I was hoping you'd say that. This is going to be expensive, though. HOA litigation isn't cheap. I've got savings, and I'm willing to take out a loan if necessary. They don't get to just destroy my property and walk away. We filed the lawsuit 2 weeks later. The complaint was 37 pages long and included counts for trespass, destruction of property, violation of due process, breach of fiduciary duty, negligence, gross negligence, willful misconduct, and violation of city ordinances. We sued the HOA as an entity, Patricia Pennington individually, and the other 4 board members individually. The reaction was swift and predictable. Patricia sent out a mass email to the entire neighborhood painting me as a troublemaker who was trying to destroy the community over a few trees. She claimed my lawsuit was threatening everyone's property values, and that if I won, it could force the HOA to levy special assessments of thousands of dollars per household. Several neighbors who I'd thought were friends stopped talking to me. I got angry notes left on my door. Someone spray-painted "Tree Hugger" on my driveway. The Hendersons made a point of glaring at me whenever they saw me outside. But I also started hearing from other homeowners who'd had their own problems with Patricia and the board. A man named George who lived 5 streets over called me to say the board had fined him $5,000 for painting his house trim the wrong shade of beige. A woman named Susan said they'd threatened to foreclose on her house over unpaid fines for having her trash cans visible from the street. An elderly couple, the Rodriguezes, told me the board had denied their request to install a wheelchair ramp, claiming it didn't meet aesthetic standards. Marcus was delighted with these accounts. This establishes pattern and practice. Can any of these people document their complaints? They could. Over the next month, I collected a file of HOA abuse stories that was 3 inches thick. George had photographs and written correspondence. Susan had certified mail receipts and payment records showing arbitrary fines. The Rodriguezes had medical documentation proving the need for the ramp and letters from the board denying their request. We amended the complaint to include class action allegations on behalf of all homeowners who'd been subjected to arbitrary and capricious board actions. That really set off Patricia. She showed up at my house one evening, flanked by 2 board members I recognized from community meetings. One was a man named Richard Sutton, who owned a car dealership and seemed to think that made him important. The other was a woman named Deborah Mills, who was basically Patricia's yes woman. I opened the door but didn't invite them in. "What do you want?" "We're here to make you an offer," Patricia said, her voice tight with barely controlled anger. "Drop the lawsuit and we'll pay you $20,000 for your trees." "No. $25,000 and we'll waive your HOA fees for a year." "Not interested." Richard stepped forward. "Look, pal, you're making a big mistake. You can't win against the HOA. We've got insurance and lawyers and we'll drag this out for years. Meanwhile, you'll spend a fortune in legal fees and everyone in the neighborhood will hate you." "Everyone in the neighborhood already seems to hate me. thanks to Patricia's email campaign, so I've got nothing to lose. $30,000, Patricia said. Final offer. You cut down trees that would cost $150,000 to replace with comparable specimens. You violated city law. You violated your own bylaws. You violated my property rights. And you did it all because you enjoy wielding power over people. So no, I'm not taking $30,000. I'll see you in court. Deborah spoke up for the first time. You'll regret this. Is that a threat? It's a promise, Patricia said. Good luck finding anyone in this neighborhood who'll talk to you after we're done. They left, and I immediately called Marcus to report the visit. He made notes and said it could potentially be used as evidence of intimidation. The legal process moved slowly. Discovery took months, during which we requested years' worth of HOA board meeting minutes, financial records, correspondence, and emails. Patricia and the board fought every request, claiming privacy concerns and confidentiality. But the court ordered them to comply, and what we found was damning. The board had been running the HOA like their personal fiefdom. Patricia had approved expenditures without votes. They'd awarded contracts to companies owned by Richard's relatives. They'd collected hundreds of thousands in fines, many of which appeared to be completely arbitrary. In one case, they'd fined someone for having grass that was too green and stood out from neighboring lawns. Most damning of all, we found emails between Patricia and Mary Henderson from across the street. Mary had explicitly told Patricia that my oak trees blocked their mountain view and asked what could be done. Patricia had responded that she'd take care of it, and that the Hendersons didn't need to worry about proper procedures because she'd handle everything. There was no record of any notice being mailed to me. There was no record of a board vote. There was no record of any legitimate complaint process being followed. Patricia had simply ordered the trees cut down because her friend wanted a better view. We also found that the HOA had never obtained the required city permit. When confronted about this during a deposition, Patricia claimed she didn't know a permit was required. But we found emails showing that the tree removal company had specifically asked about permits, and she'd told them not to worry about it. Marcus filed a motion for summary judgment on several counts, arguing that the evidence was so clear that no trial was necessary. The judge agreed on the trespass and property destruction counts, ruling that the HOA was clearly liable. The question of damages, however, would require a trial. The trial was scheduled for 14 months after I'd filed the initial complaint. It was set to last 2 weeks in the Maricopa County Superior Court in Phoenix. I was nervous the morning the trial started. I'd never been involved in litigation before, and the courtroom felt intimidating. But Marcus was confident. "We've got them cold," he said. "Just tell the truth and don't let their lawyer rattle you." The HOA's attorney was a slick corporate type named Bradley Morrison, who represented dozens of HOAs throughout Arizona. His strategy became clear during opening statements. Blame me. He argued that I'd been a difficult homeowner who refused to maintain my property according to community standards, that I'd been warned multiple times about my trees, and that the HOA had acted appropriately to protect property values. It was all nonsense, and we had evidence to prove it. But he delivered it convincingly, and I worried the jury might believe him. The trial itself was exhausting. We spent days going through documents, emails, and testimony. Marcus called me to the stand first, and I walked the jury through everything. Buying the house specifically because of the mature trees, waking up to chainsaws, the confrontation with Patricia, discovering the violations of law and procedure. Bradley Cross examined me aggressively, trying to suggest I was exaggerating, that I'd been notified and ignored the warnings, that my real goal was to hurt the HOA financially. But I stuck to the facts, and I could see some jury members nodding sympathetically as I described watching my 60-year-old trees being destroyed. We called an arborist who testified that the oak trees had been healthy specimens worth approximately $175,000 to replace with comparable mature trees. The HOA's expert argued they were only worth $10,000, but our expert demolished his methodology on cross-examination. We called a real estate appraiser who testified that my property value had decreased by at least $50,000 due to the loss of the mature trees. The HOA's appraiser claimed there was no impact, but she'd never actually visited my property or the neighborhood. We called George, Susan, and the Rodriguezes, who testified about their own experiences with the board's arbitrary and capricious actions. Bradley objected repeatedly, but the judge allowed the testimony as evidence of pattern and practice. Then Marcus did something brilliant. He called Mary Henderson to the stand. Mary clearly didn't want to be there. She squirmed in her seat as Marcus walked her through the timeline. Yes, she'd complained to Patricia about my trees blocking her view. Yes, Patricia had promised to take care of it. No, she didn't know that proper procedures hadn't been followed. No, she hadn't realized that city permits were required. Did you offer to pay for the tree removal? Marcus asked. We discussed contributing to costs. How much? Patricia said it wouldn't be necessary, that the HOA would handle it, because the cost would be spread among all the homeowners, not just you getting the benefit of the improved view. Is that correct? I don't know about that. But the damage was done. The jury could see that this had been a personal favor, not a legitimate community action. Then Patricia took the stand. She was defensive from the start, insisting that everything had been done properly and by the book. Marcus let her talk, let her dig herself deeper, and then he started presenting the evidence. The emails, the lack of meeting minutes, the absence of any vote, the missing city permit. Miss Pennington, did you personally authorize the removal of Mr. Xanders' trees? I acted on behalf of the board. I didn't ask that. Did you personally authorize the removal? Yes, but did you hold a board meeting to discuss this action? We discussed it informally. Is there any record of this informal discussion? Not everything needs to be documented. Marcus pulled out the bylaws. According to the HOA bylaws, Section 7, all board decisions affecting individual properties must be made by majority vote at a properly noticed meeting. Did you follow this procedure? We operate with some flexibility. Yes or no, Miss Pennington? Did you follow the procedure outlined in the bylaws? She hesitated. Not formally, no. Did you send Mr. Xanders written notice of the intent to remove his trees? We mailed a notice. Can you produce evidence of this mailing? The office should have records. We've subpoenaed all office records. There's no evidence of any notice being sent to Mr. Xanders, so I'll ask again. Did you send him notice? Her face flushed red. If the office doesn't have records, then perhaps it was overlooked. So no notice was sent. Apparently not. Did you obtain a city permit as required by Scottsdale ordinances for the removal of heritage trees? I didn't realize a permit was needed. Marcus showed the jury the email from the tree removal company specifically asking about permits. You were explicitly informed that permits might be required, weren't you? I don't recall that email. It's from your email account. Are you saying you didn't write this response telling them not to worry about permits? She was trapped. I may have. I don't remember every email. Miss Pennington, isn't it true that you ordered Mr. Xanders' trees removed as a personal favor to Mrs. Henderson, your friend, without following any proper procedures, without notifying Mr. Xanders and without regard for the law. That's not true. Then explain these emails between you and Mrs. Henderson, where she thanks you for taking care of the tree problem and mentions that her views are now absolutely spectacular. Patricia's lawyer objected, but the judge overruled him. Patricia sat there, her face now pale, unable to provide a coherent explanation. The rest of the trial was almost anticlimactic. The HOA's insurance company representative testified about coverage limits. Financial experts discussed the HOA's assets and the community center's value. City officials testified about the permit violations and the fines that had been assessed against the HOA. In closing arguments, Marcus laid it all out for the jury. This case is about abuse of power. Patricia Pennington and her board acted as petty tyrants, destroying Mr. Xanders' property without notice, without proper procedure, and without regard for the law. They did it as a favor for a friend. They did it because they could, or so they thought. But in America, we have property rights. We have laws, and when those in power abuse their authority, there are consequences. Mr. Xanders is asking you to hold the HOA accountable, to award damages that reflect not just the value of what was destroyed, but the willful and malicious nature of how it was destroyed. Thank you. The jury deliberated for 2 days. When they came back, the forewoman read the verdict: liable on all counts. Compensatory damages: $225,000 for tree replacement costs and diminished property value. Punitive damages: $1 million for gross negligence and willful misconduct. I nearly collapsed in relief. $1.2 million, but Marcus wasn't done. He immediately filed motions asking the court to remove the board, place the HOA in receivership, and consider additional remedies given the pattern of abuse documented during the trial. The judge scheduled a hearing for 2 weeks later. In the meantime, the verdict made local news. Reporters called me for interviews. The story was picked up by national HOA reform advocates. Patricia and the board became the poster children for HOA abuse of power. The HOA's insurance covered up to $500,000. That meant the HOA itself was on the hook for the remaining $700,000. Their reserves totaled about $300,000. Even if they liquidated everything, they'd be short $400,000. At the hearing, Marcus argued that the only way to satisfy the judgment without unfairly burdening innocent homeowners with massive special assessments was to sell the community center. It was the HOA's most valuable asset, and selling it would cover the judgment and leave money left over for the association. The HOA's attorney argued this would deprive homeowners of amenities they'd paid for. But Marcus countered that the board's illegal actions had created this situation, and innocent homeowners shouldn't have to pay for the board's misconduct. The judge took a week to consider. When he issued his ruling, it was even better than I'd hoped. He removed Patricia Pennington and the entire board from their positions immediately, banned them from serving on the board in the future, and referred the matter to the Scottsdale City Attorney's Office for potential criminal charges related to the permit violations. He appointed a receiver to manage the HOA's affairs and ordered the community center to be sold at fair market value, with proceeds going first to satisfy the judgment, then to establish a properly managed reserve fund for the HOA. He also ordered sweeping reforms. All future board meetings had to be properly noticed and open to homeowners. All financial records had to be available for inspection, and any fines over $500 required approval by vote of the full membership, not just the board. An independent management company would be hired to run day-to-day operations. The community center sold 4 months later for $2.1 million. After satisfying my judgment and paying the receiver's fees and attorney costs, there was about $200,000 left for the HOA's reserves. I used some of my award to pay Marcus's legal fees, which were substantial but worth every penny. The rest I put into escrow for when I eventually sold the house. I had 3 new oak trees planted in my front yard. They were young saplings, nowhere near the size of what I'd lost, but they'd grow in time. The Scottsdale city attorney decided to prosecute Patricia for violating tree removal ordinances. It was technically a misdemeanor, but given the dollar amounts involved and the willful nature of the violations, they took it seriously. She ended up pleading guilty and paying a $10,000 fine plus restitution to the city. She didn't do any jail time, but she had a criminal record now. The new HOA board, elected by the homeowners 6 months after my trial concluded, was completely different. They were reasonable people who understood that an HOA should serve the community, not rule it. They reduced unnecessary fees, stopped the arbitrary fines, and focused on basic maintenance and community events. George got his paint fine refunded. Susan got her garbage can fines dismissed. The Rodriguezes got approval for their wheelchair ramp, which the new board even helped partially fund from the reserves. Some neighbors apologized to me for how they'd treated me during the lawsuit. Others never did. The Hendersons moved away about 8 months after the trial, presumably because they couldn't stand living across from me anymore. I didn't mind. The community center sale was actually a blessing in disguise. The buyer was a private fitness company that opened it as a gym, but they gave Ridgemont Heights residents a significant discount on memberships. Most people agreed that having professional management of the facility was better than the HOA trying to run it themselves. I started getting calls from homeowners in other subdivisions asking for advice on fighting their own HOAs. I wasn't a lawyer and couldn't represent them, but I connected several with Marcus, who ended up taking on a few more cases. He told me I'd started something of a movement in the Phoenix area toward HOA accountability. About a year after the trial, I got a call from a reporter at the Arizona Republic who was doing a story on HOA reform efforts in the state legislature. Apparently, my case had inspired several lawmakers to propose new legislation strengthening homeowner rights and limiting HOA authority. They wanted to interview me. The article ran on the front page of the local section, with a photo of me standing in my front yard next to my young oak trees. The headline was David vs. Goliath. Homeowners fight against HOA sparks reform movement. I framed that article and hung it in my home office. Not long after, I ran into Richard Sutton, the former board member, at a grocery store. He looked uncomfortable when he saw me, but to his credit, he came over. "I owe you an apology," he said. "I went along with Patricia because she seemed to know what she was doing and I didn't want to rock the boat. I should have stood up to her. What happened to your trees was wrong." It was probably the most genuine apology I received from anyone involved, and I respected him for having the courage to say it. "I appreciate that," I said. "I hope you learned something from all this." "I did. I'll never serve on an HOA board again," he said with a rueful smile. "I'm not cut out for it." 2 years after the trees were cut down, my property value had actually increased. The notoriety of the case, combined with the HOA reforms, made Ridgemont Heights an attractive place to live. People wanted to be in a community where the HOA wasn't run by tyrants. A real estate agent told me that when she showed houses in the neighborhood, she specifically mentioned the lawsuit and the reforms as selling points. People are terrified of HOAs, she said. Knowing that yours has proper oversight and accountability is a huge plus. I never planned to become an HOA reform advocate. I just wanted to live peacefully in my house with my trees. But sometimes life pushes you into roles you never expected. Looking back, I'm glad I fought. Not just for myself, but for everyone who'd been bullied by Patricia and boards like hers. The young oak trees in my yard were growing well, reaching about 12 feet tall by the third year. They'd never replace what I'd lost, but they were a reminder that good things could grow from bad situations. I spent evenings sitting on my porch, watching them sway in the desert breeze, thinking about how far things had come. I also made sure to stay involved with the new HOA board, not as a member but as an engaged homeowner. I attended meetings regularly, asked questions, and kept an eye on things. Not because I was looking for problems, but because I'd learned that oversight was essential. An HOA only worked when homeowners paid attention. Marcus and I stayed in touch. He'd occasionally send me articles about HOA cases around the country, especially ones where homeowners had won significant victories. "You started something," he told me once over coffee. "More people are willing to fight now because they saw what you accomplished." That felt good. The whole experience had been exhausting, stressful, and expensive, even with the judgment in my favor. But knowing it had made a difference beyond just my situation gave it meaning. Patricia disappeared from the neighborhood entirely. I heard through the grapevine that she'd moved to Fountain Hills, a nearby community. I hoped she wasn't on any HOA boards there, but I wouldn't have been surprised if she was. People like her were drawn to positions of petty power. The tree removal company that had cut down my oaks went out of business about a year after the trial. I don't know if it was related to their role in what happened, but I noticed they'd been named in the lawsuit, and the publicity hadn't been good for them. A different company took over their contracts. Meanwhile, the Arizona legislature actually passed some of the reforms that had been proposed. New state laws required HOAs to follow stricter procedures before taking action against homeowners, increased transparency requirements, and made it easier for homeowners to challenge arbitrary decisions. The governor signed the bill in a ceremony where I was invited to attend. I stood in the background as he gave a speech about property rights and the need for accountability in HOA governance. This legislation wouldn't exist without homeowners like Xavier Xanders, who had the courage to stand up against abuse of authority, the governor said. Hearing my name mentioned by the governor of Arizona was surreal. Life settled into a new normal. I dated occasionally, though being the guy who sued his HOA was sometimes an interesting conversation starter. Some women found it admirable. Others thought I was probably difficult to live with. I was okay with it either way. I'd learned a lot about standing up for myself and not backing down when I knew I was right. My career as a software engineer continued without incident. My coworkers had followed the case with interest, and several had their own HOA horror stories. I became the unofficial office expert on HOA issues, which was amusing but also a bit exhausting. Everyone wanted advice on their disputes. The young oak trees kept growing, and I planted some other native plants around them: desert willow, mesquite, palo verde. My yard became a showcase for desert landscaping that didn't require excessive water or maintenance. The new HOA board appreciated that I was working with the environment rather than against it. One evening, about 3 years after everything started, I was watering my young oaks when a car pulled up. A woman in her 30s got out, looking nervous. "Are you Xavier Xanders?" she asked. "That's me." "I'm Jennifer Lopez," she said, then quickly added, "No relation to the famous one." I live in the Clearwater Ranch subdivision in Mesa. Our HOA is trying to fine me $15,000 because I put up a solar panel without approval. I heard about your case, and I was hoping you could give me some advice. I invited her to sit on my porch, and we talked for over an hour. I explained what I'd learned about HOA law, proper procedures, and the importance of documentation. I gave her Marcus's contact information and told her about the new state laws that might help her case. The key is not to back down, I said. If you know you're right, fight for it. Document everything. Get legal advice early, and don't let them intimidate you. She thanked me profusely and left with renewed determination. I never found out how her case turned out, but I hoped she won. These encounters became more common. Every few months, someone would track me down asking for advice or just wanting to share their own HOA nightmare. I started thinking about writing a guide for homeowners on how to deal with HOA disputes. Maybe it could help people avoid some of the mistakes I'd made or give them courage to stand up for their rights. The 4th anniversary of the tree cutting came and went. My oaks were now about 20 feet tall, healthy and strong. They'd never be the massive 60-year-old trees I'd lost, but I'd grown attached to them. I'd planted them with my own hands, nurtured them, and watched them grow. There was something special about that. I also noticed that the neighborhood had changed in subtle ways. People seemed more engaged with the HOA, more willing to speak up at meetings, more aware of their rights. The culture of fear that Patricia had cultivated was gone, replaced by something healthier. A community of homeowners who worked together rather than being ruled by a dictatorial board. Marcus called me one day with an interesting proposition. "I'm putting together a book about HOA reform," he said. "Would you be willing to let me include your case as a chapter? I'd change names if you wanted, but I think your story could help a lot of people." "Use my real name," I said. "I'm not hiding from what happened. If it helps other people, I'm all for it." The book came out the following year and became something of a bestseller in the niche world of HOA law. Marcus sent me a copy with an inscription, "To Xavier, who proved that one person can make a difference." I kept that book on my coffee table, and it was a conversation starter when people visited. Some thought I was crazy for having fought so hard over trees. Others understood that it wasn't really about the trees at all. It was about the principle that no one, not even an HOA board, had the right to destroy your property without following proper procedures and respecting your rights. Looking back on everything, I realized I'd been changed by the experience. I was less willing to accept things just because someone in authority said so. I was more aware of my rights and more willing to defend them. I'd also developed a thick skin about criticism and learned that doing the right thing wasn't always popular. The community center, now a privately run gym, was thriving. I joined as a member and went there several times a week. It was strange working out in the building I'd essentially taken from the HOA, but it also felt like justice. The HOA's most valuable asset had been sold because of their misconduct, and it was now serving the community in a different way. I sometimes wondered what Patricia was doing. I'd heard rumors she was on another HOA board in her new community, but I never verified it. Part of me hoped she'd learned something from our legal battle, but another part of me suspected people like her rarely changed. They just found new venues for their need to control others. The Hendersons' old house across the street had been sold twice since they moved. The current owners, a young couple with 2 kids, were friendly and normal. They'd heard about the lawsuit from neighbors and asked me about it once. I gave them the short version, and they shook their heads in amazement. "We almost didn't buy in an HOA neighborhood because of stories like that," the husband said. "But everyone told us this one was different now, that things had changed." They have, I assured him. Just stay involved and pay attention. HOAs only become problems when people don't participate. That became my standard advice to new neighbors. Stay engaged, attend meetings, know your rights, and don't be afraid to speak up. Most people seemed to appreciate it, though a few thought I was paranoid. 5 years after the chainsaws woke me that terrible Tuesday morning, I finally felt like I'd moved past it all. The anger had faded, replaced by a sense of satisfaction that I'd fought back and won. The young oak trees were now over 30 feet tall, providing shade and beauty to my yard. They'd probably live for another 50 or 60 years if properly cared for, long after I was gone. I'd learned an important lesson. Institutions, whether HOAs or anything else, only have the power we give them. When they abuse that power, we have the right and the responsibility to fight back. It won't be easy, it won't be cheap, and it won't make you popular. But it's necessary. The state's new HOA laws were working. I'd heard of several cases where homeowners had successfully challenged improper board actions, and several HOAs had reformed their practices to avoid legal trouble. The landscape was changing, slowly but surely. Marcus retired from active practice, but continued consulting on major HOA cases. He'd call me occasionally to share war stories or ask my opinion on something. We'd become friends through the shared experience of battle, and I valued his wisdom and perspective. My career had advanced. The notoriety from the lawsuit hadn't hurt professionally. If anything, it had helped. People saw me as someone who stood up for his principles, which was valued in the tech industry. I'd been promoted twice and was now leading a team of developers. Dating had improved too. I'd met someone, a woman named Jessica Lawrence, who worked as a teacher. She thought my HOA story was both crazy and admirable. "You stood up for yourself," she said. "That's attractive." We'd been seeing each other for 8 months, and things were getting serious. She loved my oak trees and the desert landscaping I'd created. "This yard tells a story," she said one evening as we sat on the porch watching the sunset. "A story about resilience and growth." She was right. The yard did tell a story, my story. From destruction to renewal, from anger to action, from defeat to victory. I occasionally gave talks at homeowner association meetings around the Phoenix area, sharing my experience and encouraging people to know their rights. I wasn't trying to turn people against HOAs entirely. When run properly, they could be beneficial organizations that maintained property values and provided amenities. But they needed oversight and accountability. The key lessons I always emphasized were simple. Document everything, know your covenant and bylaws, attend meetings, and don't be afraid to question authority. And if an HOA does violate your rights, don't back down. Find a good attorney, gather your evidence, and fight. Some people took that advice to heart. Others nodded politely and then went back to ignoring their HOA until it was too late. You can't save everyone, but you can at least try to educate them. 6 years after it all started, I stood in my front yard looking at my oak trees, now 40 feet tall and thriving. They weren't the giants I'd lost, but they were growing strong and healthy. In another decade, they'd provide substantial shade. In 2 decades, they'd be impressive specimens. In 50 years, they'd be what my original trees had been. Landmarks, heritage trees, living monuments. I'd probably be gone by then, but the trees would remain. And maybe, just maybe, whoever owned this house in 50 years would appreciate them and fight to protect them if necessary. Maybe they'd know the story of how these trees came to be here, planted in the aftermath of destruction, symbols of resistance against arbitrary authority. That was the legacy I wanted to leave. Not just the trees themselves, but the lesson that you can fight back against injustice and win. It won't be easy, and it won't be quick, but it's possible. That Tuesday morning 6 years ago, when I woke to the sound of chainsaws destroying my 60-year-old oak trees, I'd thought it was the worst day of my life. In a way, it had been. But it had also been the beginning of something important. A fight for justice that had resulted in real change, not just for me but for homeowners throughout Arizona. The community center I'd taken from the HOA through legal action was now serving people better than it ever had under HOA management. The reforms I'd inadvertently sparked were protecting other homeowners from similar abuse. And my oak trees, young and strong, were growing toward the sky, a living reminder that from destruction can come renewal, and from anger can come action that changes things for the better. I never thought I'd be grateful for that awful Tuesday morning, but in a strange way I was. It had tested me, challenged me, and ultimately shown me what I was capable of when pushed to defend what was right. Patricia and her board had thought they could bulldoze over me just like they had over countless other homeowners. They'd been wrong, and they'd paid a heavy price for that mistake. The sun was setting over the Camelback Mountains, painting the sky in shades of orange and purple. Jessica came out to join me, slipping her hand into mine. "Thinking about the trees again?" she asked. "Always," I said, but not with anger anymore, with pride. She squeezed my hand. "You should be proud, you made a difference." We stood there together as the desert evening cooled, watching my oak trees sway gently in the breeze. They were more than just trees now. They were symbols of justice served, of accountability enforced, of one person's refusal to accept injustice. And they were beautiful.